Next, I am pleased to welcome to the program Kenneth Marcus, founder and chairman of the Louis D. Brandeis Center for Human Rights Under Law. The Brandeis Center is actively involved in countering anti-Semitism on college and university campuses, including by filing Title VI complaints with the U.S. Department of Education on behalf of Jewish students facing discrimination and harassment. Mr. Marcus, go ahead, please.
Hi, I'm Kenneth Marcus, chairman of the Louis D. Brandeis Center for Human Rights Under Law, and also former Assistant Secretary of Education for Civil Rights. I'd like to say a few words about the use of the IHRA working definition of anti-Semitism, including its guiding examples relative to Israel, by colleges and universities. I'm sometimes asked whether a particular college or university should adopt the IHRA working definition of anti-Semitism. And I think it's a great question because the fact is that the IHRA working definition is, among other things, an excellent educational tool that institutions like colleges, universities, and public schools can use in order to inform their constituents, their students, their faculty, their staff, about what is anti-Semitic and what isn't, in order that one might avoid inadvertently crossing a line into what is, in fact, a form of hate or bias. But it seems to me that the question whether a university or college should adopt the IHRA working definition of anti-Semitism often ignores a more fundamental point, which is that in virtually all cases, whether they know it or not, they already have, which is to say, they may or may not have adopted the IHRA working definition of anti-Semitism with all of the symbolism and hoopla that sometimes attends a formal announcement by a high-placed leader like a university president. But the fact is that in a very real sense, virtually every American college and university is bound by certain aspects of the IHRA working definition of anti-Semitism, whether they know it or not, whether they speak about it or not, whether they have an announcement or not, whether they have a formal adoption or not. Universities and colleges in the United States nearly all receive some form of financial assistance from the U.S. Department of Education. And when they do so, they sign formal assurances or certifications indicating that they will comply with applicable federal laws, statutes, regulations, executive orders. And that unquestionably includes not only Title VI of the Civil Rights Act of 1964, which in very broad terms prohibits discrimination on the basis of race, color, or national origin, including discrimination against Jewish Americans, but also Executive Order 13899, which since 2019 has incorporated the IHRA working definition of anti-Semitism and its examples in the sense that it directs U.S. federal officials, such as the head of the U.S. Department of Education's Office for Civil Rights, to consider the IHRA definition when evaluating claims that a recipient institution is violating the rights of Jewish students to determine whether the intent of the conduct is anti-Semitic. So in a real sense, first, federal officials are already evaluating the response of universities to anti-Semitism under the IHRA working definition. That's not just a practice, it's actually a formal policy. IHRA does not restrict speech critical of Israel. Second, IHRA recognizes that much criticism of Israel has nothing to do with anti-Semitism. And third, IHRA itself is simply a definition. That is to say, it tells us what we mean by words. It is actionable. It is binding only to the extent that it is made binding by applicable governmental entities. So we now have a situation in which IHRA is indispensable to the regulatory fabric by which universities are governed. And in fact, there are some people who agree very strongly that IHRA is not only the one internationally agreed upon definition of anti-Semitism, but that it is the best. But there are others who disagree. And you know what? The fact is that we have never had in the United States an important civil rights measure that wasn't controversial in some sense. From the 14th Amendment to the Civil Rights Act of 1964, to all of the statutes that protect the rights of Americans, every single one of them has faced some degree of resistance. The IHRA working definition is unique in the extent of the support it has received, not only among a very large number of major Jewish organizations, many of which do not agree with one another on very much, but also by half of our states, by over 30 nations around the world, and by over 1,000 other entities. I do think that college and university officials, whether they adopt IHRA or not, should be transparent about the extent to which IHRA, under the executive order, is a part of their regulatory fabric. Colleges and universities routinely educate and inform their students and faculty members about federal law relating to analogous civil rights areas like sexual harassment or reasonable accommodation for disabilities. It is entirely appropriate for colleges and universities to provide guidance, education, training, and orientation to their constituent members about how IHRA applies. I think it's important for colleges and universities to make clear that IHRA is not a tool for limiting speech, but that it is nevertheless an important tool, an educational tool, and also a tool for understanding that there are times in which, whether we know it or not, our conduct crosses the line. And I think it is entirely appropriate for leaders to make sure that those lines are drawn very clearly, and to the extent that those lines are part of our federal and state law, that they're widely known. IHRA is today not only the one internationally agreed upon definition of anti-Semitism, but it has rapidly become the most influential aspect of our federal regulation when it comes to anti-Semitism. This is an important development, and I think it is an entirely salutary one that it is increasingly adopted, as well as understood, embraced, and educated around by a large number of institutions. It is very good to be with you today, and I thank you.
Thank you, Mr. Marcus, for your insights and all the meaningful work the Brandeis Center does for Jewish students.